Welcome to the Freedom Unchained channel, back with another lesson from George Gordon Common Law School. This is going to be lesson 8. I'm not sure what happened to lesson 7. I haven't been able to find lesson 7 yet, so we will just continue here with lesson 8. If you haven't watched all the videos from the beginning, please check out the playlist in the description below to get caught up. If I ever find lesson 7, I will add it in here for everybody into the playlist in order. I'm getting a lot of reactions that everybody's enjoying this and they're waiting for the next video, so I'll try my hardest to keep them coming every day. I'll even try to post more than one if I can. So if you guys enjoy this, please share it around with all your friends and family. Please leave a comment and let's get a conversation started. If you're not subscribed yet, please subscribe and hit the bell notification so you can get the next video uploaded. And let's just get to it.
Well, greetings again. We're up to lesson 8. And I'm going to talk to you today about jurisdiction, because jurisdiction is one of many vital elements that you're going to use in your defense in a criminal prosecution. When you're being prosecuted, you have to keep in mind that there is no single way to defend your case. What I'm saying by that is you don't want to rely upon just one angle of defense. So many times I see pro se's go into the courtroom and they're hanging their hat, so to speak, on jurisdiction, or they're hanging their hat on the exclusionary rule. Remember Almeida Sanchez? The only issue that the Supreme Court had to decide was the Fourth Amendment search and seizure issue. Well, what if the court had ruled against him on the Fourth Amendment issue? That would have been disastrous for him, and it can be disastrous for you, because we want to put in 30 motions and briefs. We want to raise 30 federal questions at the scene of the crime, in the jail, insofar as the law is concerned, the facts surrounding the case, so that no matter what happens, if it's not jurisdiction, then it's rights, or it's rules of procedure, or it's search and seizure, or it's Fifth Amendment. All right? So today we're going to talk about jurisdiction. Bill Avery is the one who pioneered jurisdiction, and the first time I heard about it was about a year ago. And I've been arguing cases in court for 4 years and winning consistently without ever bringing up the subject matter or the issue of jurisdiction, because I didn't understand it and didn't know it, couldn't use it. So if you're looking at your course outline, let's take a look at this thing called jurisdiction. It includes the court system. It includes subject matter called geography. Then there's a topic called subject matter. What is the proper subject matter for the court to determine in its jurisdiction? Then jurisdiction over the person, status, and then a remedy. How does the court affect a remedy? Well, to begin, I'm going to take Bovier's Law Dictionary and I'm going to scan through the subject of jurisdiction. And let's see if we can get some dictionary definitions under our belt as we get started. Looking under jurisdiction here then, we're talking about the authority by which judicial officers take cognizance of and decide causes. It is the power to hear and to determine a cause. And then there's some citations below it. Well then, the first thing that we want to get in our mind is, then, it's the power to hear a cause or matter. If you don't have the power to even hear the matter, well then the court doesn't have jurisdiction. Jurisdiction can be questioned and challenged at any time. That's important, so let's repeat it. Jurisdiction can be challenged at any time. You can be sentenced and serving 20 years in jail, and on the 11th year, you can come back and say, wait a minute, why, you tried me in the patent court, and the patent court doesn't have jurisdiction to hear these criminal matters for which I'm charged and sentenced to jail, and then raise by motion that subject matter, that challenge to the jurisdiction. All right, so it includes power to enforce the execution of what is decreed. So the court has to have the power then to enforce whatever it's going to determine. Then there's a thing called appellate jurisdiction. Is that given by the appeal, or given by appeal from the judgment of another court? So some courts are appellate courts and have appellate jurisdiction. That's a more powerful court than the court of original jurisdiction then, because the lower court can convict you, but the higher court can reverse the decision of the lower court. Then we have assistant jurisdiction, is that afforded by a court of chancery in aid of a court of law, as for example by a bill of discovery or for the perpetuation of testimony and the like. And it goes on and on here, talking about jurisdiction. Remember, we're using Bovier's 1870 Law Dictionary. These are $150. You can order them from the school. I'm going to use this one almost exclusively in our dictionary terms and definitions. If you have one, fine. If you don't have one, then you're going to have to go with Black's or someone else. But remember, you have to have a competent law dictionary in order to come to grips with the terms, phrases, etc. that are going to be used in that courtroom. All right, so now, with jurisdiction in our mind, then, it has something to do with the ability of the court to effect a remedy. It has something to do with the ability of the court to hear a matter. Now, there are many, many different kinds of courts. I don't even know how many, but let's run through a few so that you can have an idea of what courts listen to and how many there are. Okay? We know we have traffic courts, don't we? And we have OSHA courts, and we have EPA courts, and we have courts of patent matters, and admiralty courts, and we have district courts, and then we have appellate courts, courts of appeals. We have state supreme courts. We have federal supreme courts. And there are all kinds of administrative courts. And you know, all of these administrative agencies, like the Department of Health, Education, and Welfare in your state, or the Department of Employment, they hold hearings, don't they? These are administrative law courts. So there are all types of courts, and those courts have jurisdiction over certain subject matter. Let's take an example here. Let's suppose that you're charged with armed robbery. And they haul you into the Department of Employment, and they bring you up to a hearing officer, and they want to charge you with this crime. All right, obviously, then, we're talking about a court that has no jurisdiction to hear this matter. They have jurisdiction which is conferred by law. Now, if it's conferred by law, who conferred that jurisdiction? Well, your legislature did, or your state constitution conferred that jurisdiction. So what happens is you look in your state constitution, and you're going to find that, for instance, in Idaho, the jurisdiction or the whole branch or the whole subject matter of the judicial branch of government comes from Article 5. And we take a look in Article 5, and then it spells out the courts of original jurisdiction, which are called district courts. And so district courts, then, are those courts of original jurisdiction in criminal and civil matters. Remember the 2-2-2 rule. Your court is going to be divided into equity and common law, and equity and common law are divided into just two branches, and that's criminal and civil. All right? Now, when you're talking about civil and criminal, well then some courts listen to both civil and criminal matters. And so when you're talking about the traffic court, then you're talking about a court that's listening to criminal matters. They're called misdemeanors. Now, if they're called infractions, which many states have these new infraction laws, and Idaho is coming up with its own infraction law shortly, that infraction law then is civil. And the legislature, by statute, will spell out what those jurisdiction remedies are, what the limits of the jurisdiction is, what it covers, what the subject matter is. All right, so in our state, the legislature says speeding is a misdemeanor at this time. That's criminal. It also says that selling beer to minors under 19 is a misdemeanor, and that's criminal. So you have to be taken to a magistrate. And the magistrate is, in effect, a trainee judge. It's a division or a department below that of the district courts. And in Idaho, they're called magistrates of the 4th Judicial District in and for the county of Ada. So this magistrate has limited jurisdiction. And his jurisdiction is limited by statute, and it's limited by the rules of the Supreme Court. When we get into this thing of the doctrine of the separation of powers, we'll talk about the separation of powers and how that separation works. Now, when we're talking about jurisdiction, though, we're talking about the power that this particular individual has in this particular cause of action. And you're going to be absolutely dumbfounded at how many courts operate without jurisdiction. People are brought into courts every day, and they never challenge jurisdiction or ask about jurisdiction, and they're tried, and they're convicted, and they're sentenced, and then they serve their sentence, and they come back, and that court never had the proper jurisdiction with which to try that case, or to sentence that person, or to send him to jail. Now, I know that sounds strange and bizarre, but I'm just telling you, friends, that that's the way it is. And I didn't make it that way, and that isn't 1 Gordon 14:4, and I'm going to give you some examples of that. So one of the first things that you do is to challenge the jurisdiction of the court, because if you don't challenge it, it's a right that you're waiving. It's like being tried by a complaint or information in an infamous crime. And if you don't complain that, well, wait a minute, this is an infamous crime, well, I could be put in jail for this. Therefore, and demand a grand jury indictment, you can be tried with a piece of paper that's nothing more than this. And they can bring you in and try you with a ninth grade high school girl could come in here and prosecute the case. Yesterday, I happened to be in court, and I watched two young men, 22 years old, plead guilty to burglary and malicious destruction of property. And they sat there for 30 minutes and admitted and confessed, and this judge, he's very thorough. He asked them, well, do you understand what burglary in the first degree is? Yes, I do. Well, what is burglary in the first degree? And boy, I was sitting there and I said, gosh, I think, I'm sure glad he's not asking me that question, because I'd flunk. And they said, well, burglary in the first degree is when you break in and it's between dusk and dawn. Oh, gosh, that's interesting. Second degree burglary is when you break in, I guess, during the daytime. And he went through and he made these fellows just admit and confess and plead guilty. And yes, we understand what we're doing and why. And we went home and planned and plotted this whole crime and came back. And, you know, they just laid themselves away. And the interesting thing was that they were prosecuted by information. Well, in the state of Idaho, they had a right to a grand jury indictment. That judge knew and understood that he had no jurisdiction over those people by information. That's right. And so in order for him to sentence those two people to the penitentiary, he had to get their permission and their consent before he could sentence them to the penitentiary. Does that sound strange and bizarre? Well, he has the power to do it, but only if they give him the power. Now, he didn't go up to them and tell them and explain to them. Let me explain this to you. I don't have jurisdiction over you because this is an information that's been brought before me, and therefore you're being prosecuted illegally and unlawfully. And since I don't have jurisdiction in this particular matter because the information is insufficient with which to put you in the penitentiary, I'm here to ask you for your permission today, if it's all right if I put you in jail. Would you give me your permission? Yeah, okay. Oh, fine. Now, in order for me to sentence you, I have to know what you did, so would you confess and tell me what crime you committed? I committed burglary in the first degree and malicious injury to property. Okay. Now, can you describe and tell me what the definition of first-degree burglary is? Because if you can't, you see, then I couldn't send you to prison. So let me see if we can get these definitions straight. And I'm not kidding you, friends. It took 30 minutes for him to ask all those questions. Happens every day. I said to the friend that was with me, who's a student here at the school, I said, you know, if I was those fellows, I could beat that rap, even if I was guilty and had done the act that's being alleged, because the government is prosecuting me illegally and unlawfully. And remember, under search and seizure, by now you should have covered the Weeks case and Sanchez and other cases, you know, under the Fourth Amendment. What happens when the government breaks in and seizes the evidence illegally and unlawfully? Isn't it excluded from evidence and then it can't be used? All right. What happens when you're brought into a court and you're either prosecuted in a court that lacks jurisdiction, or the court is prosecuting you in a method which denies it its jurisdiction. You see, you have to have consent. You have to grant your consent, I should say, to the judge to prosecute you in an infamous crime, anything less, or by anything less than a grand jury indictment. In Idaho, we don't have grand juries anymore. We have provision for grand juries, but they don't use them. And the citizens don't know, nor do they understand that, and so they go into courts that don't have jurisdiction, plead guilty or not guilty to crimes that are really penal clauses of contractual agreements. And then they're punished out of their own mouth with their permission and their consent. Why does a judge ask a person to take the oath? Just go into a court and watch this, and the question comes down, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? He's asking you a question. Questions can be answered yes or no. He has to ask you if you will voluntarily waive your right to be punished or prosecuted for perjury. Do you agree that if you lie, and if we can prove it, that you'll waive your right to the Fifth Amendment provision of self-incrimination and allow us to prosecute you? That's what he's really in effect asking. Because if the man had the power to compel you to testify, he wouldn't ask you, do you swear to tell the truth, the whole truth, and nothing but the truth? What he would do is say, sit down over there, boy, you are going to tell the truth, and if you lie, I'm going to put you in jail. Now I've got some questions for you. So what we're saying is that the judge recognizes the limits to his power and the limits to his jurisdiction. And so he's asking you, he'll say, clerk, would you administer the oath? Have you ever asked yourself this question? What would happen if you answered no? No, I'm not going to tell the truth. I'm going to lie. I did that once. Had a judge put me in jail twice. And I want to explain why and how that works so that you can determine whether or not you want to take the oath or not. The Supreme Court has ruled that you cannot be compelled to take an oath. Local law, local custom, and local statutes notwithstanding. Oftentimes in civil cases they'll say you cannot invoke the Fifth Amendment as a bar to prosecution or as a bar to testimony in a civil matter. And the court has ruled that, and that's true. But what about taking the oath? Well, let me show you what I did. I had a judge one time, well, let's see how this came down. They brought me into court on a civil matter, and they wanted me to take the oath and to testify concerning some things like how much wealth I had and how much property I had, and etc. Now, I just have a personal hang-up with this oath-taking thing, because in Matthew 5:33 and James 5:12, Scripture says plainly not to take an oath. Now, I'm not a particularly religious person, and I don't run around preaching to people and one thing and another, but I think that religion and religious belief and ideology is protected by the First Amendment. And so I respectfully declined to take the oath. I didn't tell them I won't give you the answers or I won't take the witness stand. I'm not telling you that I won't answer your questions. I'm just telling you that I'm not going to give you permission to put me in jail if I lied, because I am a pathological liar. And I've told that story to many people, and they'll, they just kind of, oh, you're a liar? You admit that? Yeah, that's right. Yeah, I lie all the time. And the reason that I tell people that is because Scripture also says in Romans 3 verse 4 that let God be true, though every man be a liar. And if you'll look in a Strong's Concordance at the word liar and lie, and you'll go all through Scripture and you'll find out that man does not have the inherent capability to always tell the truth. In other words, man or men, people, do not tell the truth all the time. I have the capacity to tell the truth some of the time. I have the capacity to lie some of the time. And in casual conversation, just to prove this to you so that there's no misunderstanding. When you go out to someone's house and you have dinner and someone says, wasn't that meatloaf just delicious? Well, what do? Say, no, it was horrendous. It's one of the most ghastly meatloaves I have ever tasted in my life. Now that's what you really are thinking to yourself, but you want to be polite to people, and so you never say, well, no, that wasn't good. What you do is you don't say anything, or you lie and you say, oh, it was delicious. Gosh, Mabel, that was just really wonderful. I know I've done that all my life, and I'm still kind of a pleasant sort of a fellow. I saw one of those Three Companies sitcoms not long ago, and this young man on the television, he just told the truth all the time, and just everybody hated him. I mean, every time it was kind of like putting a shmoo up in front of this fellow. And I mean, when you put this shmoo up here, he couldn't lie. He just had to tell the truth. And every time he told the truth, he just embarrassed everyone, and he told deep, dark secrets, about people that they didn't want known. And so, to illustrate the fact, I'm a pathological liar. I don't know about you now. I'm not telling you that you are. I'm just telling you that Scripture says all men are liars. Let every man be a liar. And so I'll just leave it up to you. You figure it out for yourself. And so here I am in open court, and I'm just telling the judge that. And he just, I'll bet you that in all his years on the bench, he never had a man walk into his court and say, you have a man sitting here who's going to obey the Scriptures, and he's not going to take an oath. Well, if you've ever seen that happen before, that's a rare occurrence. So he got upset and he said, well, if you don't take the oath, then I'm going to put you in jail for contempt. And my reply was, well, let me ask you this question. Are you putting me in jail because I'm telling you the truth by telling you that I'm a liar? Or are you putting me in jail for lying to you? Or are you putting me in jail because of my religious beliefs? Why are you punishing me? What's the purpose of this? And he didn't have an answer, and he just said, cast that man into the king's dungeon, and so there I went. So I stayed there for 5 days, and they brought me back again. And they said, well, now, Mr. Gordon, are you ready to take the oath? Well, let me ask you a question here, Judge. What are you going to do to me if I don't take the oath? I'll put you back in jail. Oh, well, gosh, I don't want you to do that. I don't want you to put me in jail, and I don't want you to punish me. Well, then, Mr. Gordon, all you have to do is take the oath. See how easy that is? Well, I don't know if that's too easy or not now, Judge, because it violates my religious principles. You see, in Matthew 5:33, and I think I whipped out a Bible about that time, and I read him a little story here, and he didn't like that at all. And so he said, what do you think I should do with you, Mr. Gordon? And it took me about 10 minutes. I preached him a sermon, and I said, you should not put me in jail because of Fisher versus Johnson. You should let me take the stand and tell you, let me answer yes or no. You should not put me in jail. And I went on, I gave him a few more explanations, and he said, I'm going to sentence you to 7 days in jail because you won't take this oath. To which I responded, well, let me see if I understand you correctly. Or remember the records turning around? What am I doing? I'm getting admissions and confessions from the fellow. Are you punishing me, Judge, because I'm telling you the truth when I say I am a pathological liar? Or are you going to punish me because of my religious beliefs? Or are you punishing me because I'm lying? Do you think that when I tell you that I'm a liar, that I'm lying because I really always tell the truth, and I'm telling you I'm a liar so I won't have to testify? Well, here's this guy, and I could just tell this poor judge, he's just sitting there wondering, I can't believe this. And so he threw me in jail for 7 days. I just wrote up a 35-page complaint against that judge. I'm going to prosecute the guy. I'm going to see if I can collect some money because of his violation of my rights. Because you see, when he sentenced me to 7 days in jail, he exceeded his jurisdiction. He got outside the bounds of his power. Because by statute, he can only put me in jail for 5 days, period. He already had done that, hadn't he? Now, if you're to argue, well, he could put you in jail for 5 days at different times as often as you committed this contempt of court. Okay. Well, then how do you explain that he put me in jail for 7 days. Now, if you were to leave those two questions aside, when a man walks into court and says, I can't take the oath because of my First Amendment rights to freedom of religion and expression, how do you get by that jurisdictional boundary? You see, it isn't that he wasn't warned ahead of time. I told him. First Amendment rights. I quoted the Scripture. I demand that he take judicial notice of the Bible. Wouldn't do that. All right? When the judge steps outside of his jurisdiction, then he does not have immunity from prosecution. Beginning to see now how jurisdiction works? In other words, if it's handled correctly, and that is this prosecution. Let's say, for instance, you're charged with a felony. I have a felony. Here it is, right here. I was charged with destruction of jails last year, and I filed 34 motions. 7 of those motions were based upon jurisdiction. That's about 20%, isn't it? 6, 12, 18, 24, 30. That's about 20% of my defensive maneuvering prior to trial was based upon the jurisdiction argument pioneered by Bill Avery. That's how important jurisdiction is. I won that case twice. I won it once because, as a part of my jurisdictional argument, I claimed that there was no grand jury indictment. And then the second time they reduced it to a misdemeanor, and in the state of Idaho you cannot bring a misdemeanor twice. So you can charge a felony twice, but you can't charge a felony and then a misdemeanor, or a misdemeanor and then a misdemeanor on the same event. Now, the reason that I bring that to your attention right now is I want you to learn how to do this the way we've already pioneered and the way we've already done it. And I want you to do that for a reason. People are taking our paper into the courtrooms with 5 or 6 lessons under their belts, and they're arguing these positions incorrectly. When you go in the court and you don't know what you're talking about and you argue the money issue frivolously, and then the judge rules against you on a technical move, that sets a certain amount of precedent within that judicial district or within that state. And then other judges will come around that particular judge's position and say, well, Judge Schmedley ruled in the Molko case thus and such. You see, if you have a driver's license in your pocket and you go into the traffic court and you're arguing jurisdiction, you're out to lunch and off the wall, and I don't want you to go into a court and argue jurisdiction with a driver's license because you're guilty. Because you volunteered into that regulated enterprise. It's all right for you to argue other aspects of the case and of the facts. In other words, you can use procedure. You can demand counsel of your choice. And then have the judge deny you counsel, and there's your major federal question, and you can win with the driver's license in your pocket, guilty as sin, a volunteer into a regulated enterprise, and driving down the road at 90 miles an hour in violation of the posted rules and regulations that say 55, and you can win. But don't use jurisdiction when you do it, because jurisdiction then becomes an issue of law. And that jurisdiction argument is extremely valuable for arguing on the right side of the issue. When you have a really serious case, you want to be arguing your right to a grand jury because of the infamous crime. Now I took these briefs and motions. Here's first of all the notice and demand for dismissal for want of jurisdiction. Pull that one out. You have a stack of paper there in front of you. Notice and demand for dismissal for want of jurisdiction. That's the first one that I want you to pull out. There's an actual case. Case number and all. Charged with a felony. They wanted to put me in the penitentiary for 14 years for this. I asked them, what great social benefit is it going to be to the people of Ada County to put George Gordon in the penitentiary for 14 years? Never got an answer. You know what it would cost to put me in jail for 14 years? at $15,000 a year, you're talking about something like, my goodness, $200,000. Why do you citizens out there want to spend $200,000 to put me in jail over the alleged destruction of one set of coveralls from the county jail? Absolutely insane. These prosecutors, you know, in this judicial system have no concept at all for right and wrong, and throwing people in jail or having value of money. They're just absolutely astounding. Well, pick this up then. Here's your beginning motion. Now remember, in a motion you've got three elements. One, you raise the issue. Then you've got to have the argument in support of the issue. And then third, you've got to have the authority that backs up your argument. Got that? We're going to talk about that over and over. Because 50% of your defense is wrapped up in these motions and briefs. If you can't read and write, or if you can't or don't want to file motions and paper in your case, you cannot win. So you can stop right here, turn off that TV, and go get a beer and go watch Gunsmoke. Because there's no way in the world that you're going to go into the courtroom and say, well, I can talk pretty good, so I'll just tell the judge my side of the story. Because, friends, you're going absolutely to nowheresville, and if you get involved in this kind of a fight with your government, you're going to jail, and you're going to get hurt, and you're going to get hurt real bad. And I mean that when you start running around hitting that government beehive with that club, and those bees start coming out, you better have your gloves on, and you better have your helmet and net on, because they're out to sting you, and they're out to destroy you. Now, it's one thing to go into the traffic courts and stir them up down there, but when you start stirring up Article 1, Section 10, and you start throwing the law, the Constitution of the United States, and the fundamental law of the land at these international bankers, these people that make a lot of money off of the law enforcement growth industry, I'm telling you that some people could get killed doing this. And people have told me, Gordon, you're not long for this world. And I agree. I'm probably not long for this world. But while I'm here, I'm going to train several hundred other people just like you to know and understand law just like I do, just like other people do. And then they're not faced with cutting the head off of this leader when all the chickens and all the sheep over here now don't have a leader. Every competent pro se must become a leader of and by himself, not a follower, not a member of some union or association or organization, but a leader of and by himself. I don't need any 10,000 member group behind me. I can stir up more hell in the courtroom by myself than all the members of the Ku Klux Klan combined marching up and down in front of the Capitol building in Washington, and so can you. And the way you do it is you walk into the courtroom after they've charged you with this felony, and all of a sudden you raise the issue of jurisdiction and you say, listen to this, comes now the accused appearing specially and not generally herein for the specific purpose of giving notice to the court in the state of Idaho that neither the agent of the king nor the prosecutor have adequately conferred jurisdiction in this court over either the person, the subject matter, nor the ability of the court to effect a remedy. Where do we get into this effect of a remedy? The accused at all times demands all of his rights under the Constitution of the United States and the common law, and expressly denies any jurisdiction to include Roman mercantile and executive chancery, and only recognizes that jurisdiction under the common law. The complaint fails in the most crucial of issues in that it fails to show a triable issue at law under the governmental restrictions of the Constitution of the United States for the protection of the people and the Republic. Let me stop there and tell you what we're talking about. I'm claiming that I am not a volunteer into some equitable or regulated enterprise, that I'm a person who has no contracts, who has no duty to specifically perform for my government pursuant to Hale versus Hinkle. I don't owe my government a damn thing, and I'm not going to pay them anything. That's my position. Their position has to be that either there's a corpus delicti and George Gordon has destroyed some life, some liberty, or property, or he has volunteered into a regulated enterprise And in that regulated enterprise, he has violated some one or more of the specifics of this contract. Now, that's what they have to come into the court and they have to say to me, you violated the terms and conditions of that contract. I don't have to go in there and say, I didn't voluntarily or I didn't violate these terms and conditions of the contract. It's up to them to say, you have violated the terms of the contract. All right, going on here, the complaint fails in the most crucial of issues, in that it fails to show a triable issue at law under the governmental restrictions of the Constitution of the United States for the protection of the people in the Republic. So I'm saying then, the complaint that you have here, it fails in this crucial issue because there's no triable issue before the court. What happened to anybody? You follow that? A friend of mine, to illustrate this point, one time was driving down the road, and I know some policeman got behind him, and he stopped him. This friend, he's a real actor, you know. He jumped out of the car, and he ran up to the front. Here's this policeman. He's getting out of his patrol car, and he's walking up. My friend runs up, and he looks in the front, and he gets down, he looks underneath, and he runs right back by the policeman, and he looks under the back of the car, and he looks over in the ditch. This policeman's standing there, you know, going, what on earth is the matter with this loony? My friend walks up to him, and he says, where's the body? I can't find any body. Did I run over somebody? And the policeman says, you were speeding. Speeding? What on earth is that? I mean, he's acting like a Martian who just pulled onto the earth. And here's this strange and foreign, bizarre officer coming up here saying, well, I'm stopping you for speeding. How does speeding harm anybody? You see, speeding of and by itself is no triable issue at bar. The triable issue at bar is that it's a violation of the terms and conditions of the contract. That's what the crime is. You violated the contract. Well, my friend doesn't have a driver's license, and so, of course, there's no contractual agreement or arrangement. Take a look at Almeida Sanchez, and you'll see what the Supreme Court says about licenses. All right, going on then. The complaint fails to state any cause of action by which this free and natural person that has caused a loss or damage to any other natural person's rights. In other words, the complaint fails to state how the act complained of created a damage, injury, or infringement of another person's right. What did I do that caused this loss? You know, when I drove my tractor across your front lawn and I dug these big holes in your lawn, you could walk out there and say, well, there's the damage. It has destroyed the turf, made this big hole. It's going to cost me $150 to get some new sod to put in here and to fill up the holes. See, there's a damage. You can look at it, you can see it, you can put your fingers in it, and you can probably stand in it. You can take photographs of it. You can show a damage. But how do you show a damage when you're driving 80? Beginning to see the picture? So in the absence of any cause of action being a reasonable presumption that a substantive injury has occurred and been caused by this free man by and through the alleged offense to the right or legal interest of another and subsequent valid service of process of law, no court can take jurisdiction over either the person or the subject matter.